Okay, good afternoon, everybody, and thank you for joining us. This is the afternoon session for today, where Conor will be talking about QS and construction law and the interaction between them. So without any further ado, I will hand you over to Conor. Conor, take it away.
Yeah, thank you, Julie. Good afternoon, everyone. You're all very welcome to the latest in the series of seminars we're running which relate to quantity surveying and construction law. This is the brainchild of Julie, who's been trying to bring in my experience as a quantity surveyor and basically use it to explain points of interest that have arisen in my time as a training to become a solicitor. So look, yeah, as I said, you're all very welcome. This evening we're going to look at some points of interest. These are subtle areas that have arisen during my time, and yeah, areas that I think that that people will find useful in practice, and that they can then be comfortable in utilizing them when they're back in the field. Look, obviously we're all usually we give these seminars face to face, but obviously that's not possible at the moment due to the ongoing coronavirus issue. Look, I hope you're all safe and well, because yeah, it's a difficult time for everyone. Especially, I think construction is one of the areas where, there's a large degree of uncertainty, particularly in relation to whether projects can, do they continue, do they stop, we've had many inquiries in relation to, what are my grounds for an extension of time, and obviously bringing in areas such as force majeure, people talking about frustration. So yeah, look, it's an area that's it's causing many headaches out there at the moment, and we do sympathise. And look, if we can be of any interest of any help to you guys, then look, please don't hesitate to get in touch. My colleagues are also running have been running several seminars on the topic, so but please keep an eye on the events list and join in when you can. And as I said, I hope you find those seminars of interest. Okay, so yeah, so that's a bit of background on me. Right, so we're going to introduce the agenda now. So tonight we're going to have a scoot through. We're going to look at some lump sum and remeasurement contracts that are out there. I mean, you'd be surprised about how many times this becomes an issue in practice. It surprised me. So I thought it was it's a topic that's worth revisiting and trying to clarify as well. And then we're going to move on to measurement rules. Obviously, there's been changes from the old SMM system to the new rules of measurement. So we'll touch on those as well. We're going to look at payment schedules, and in particular, the position on payment schedules following the case of Grove versus Balfour Beatty. Then we move on to payment notices, and then the position that we're now in following the case of Grove versus S&T, which is the case that will lead us into our final topic, which is the area of smash and grab adjudication. So, look, as I said, just different points of interest. I mean, please, anyone out there, if you want to, we're going to continue these seminars. So if there are areas that you'd like clarity or that you'd like us to discuss, then please just drop us a note. We're going to update the slides, and we'd be happy to try and bring some clarity to any issues that you may be experiencing. Okay, so look, we're going to move into the area of lump sum and remeasurement. Now, here I've taken the Standard Building Contract 2016 with quantities as an example. Now, we do focus on the area of JCT. The main reason for that being that, in our experience, JCT is the most popular standard form of contract. Now, obviously, there are options around NEC and FIDIC as well. But look, by and large, we come across JCT. Our clients use JCT, so we're going to run with JCT as a means of comparison and example. So yeah, so basically, as I said, remeasurement, standard building contract with quants is a remeasurement contract. Now, the work is as set out in the bills of quantities, which are prepared by the employer in accordance with the measurement rules. Now, there you'll notice that measurement rules is capitalized, and that means that it is a defined term in the contract. And defined terms obviously are on the agenda because, as we see of late, force majeure is not, in standard form contracts is not a defined term. So hence that, the area around defined terms is coming under scrutiny. And in reality, that is, force majeure is likely to start being defined in future, I guess, schedules of amendments, possibly even standard forms of contract. We wait and see where that ends up. Okay, so errors in the employer's requirements, including the production of the bills of quantities, for example, an unstated departure, erroneous quantity or description, must be corrected and treated as a variation. Now, I've included that clause. That's clause 2.13.2. That's the standard position. So where you have a remeasurement contract under the standard form, then if there is an error, then you treat it as a variation, or straightforward stuff, okay? Yeah, errors in the contractor's proposals or in the CDP analysis are to be corrected, but shall not be treated as a variation. So that's the nuance there, is that there's a contractor's proposal. Now, contractor's proposal largely relate to any design portions involved in the contract. And if there are any errors in the contractor's proposals and his associated pricing, then that is not treated as a variation. So again, nothing too confusing about that. Now, I've added the final point to remind people that, this is an area which is commonly altered through schedules of amendments. Just a bit of background on what they are is basically they're schedules that are drafted to amend the standard form position. Now, usually in my experience, as the contracts are prepared by the employer, the schedules amendments, it follows that they're weighted in the employer's favor effectively. So, and a classic clause that would be amended in the schedule is that clause 2.13.2. I mean, so because from the employer's point of view, if he has gone through the process of preparing a bill of quantities, then he doesn't want to be liable for any errors that there may be in the bill of quantities, and he is not going to want to treat it as a variation. So that's a key point. So just to, I suppose, understand the background and the reason why the standard forms are amended from time to time. So that's as I said, the standard form with quantities. Now moving on again, so we're now looking at the standard building contract without quantities. Now this one, there's more flexibility in the without quantities contract. It can be a bit of a hybrid. And what I mean by that is that if you go for pricing option A, you are going to treat that contract as a lump sum contract. Similarly, if you choose option B, then you are choosing the remeasurement contract. Basically, there is no bill of quantities prepared by the employer, and the contractor prices a specification and drawings. Now, I'm sure we're all familiar with this process. It ties in, we see it as especially in design and build contracts, but it does apply also, in the standard building contract. So this is where, employer knows what he wants. He doesn't have a bill of quantities. Various reasons why clients decide not to do them. Some can be, price to prepare. Others can be potential delay. It's a lot easier for the employer to, go through his architect and his structural engineer, possibly his M&E engineer, get the specification and drawings, and then offer that to the market. And that certainly seems to be the preferred method of business at the moment. Now, moving on. So errors in the in the ERs, for example, drawing specification schedules which are not dealt with in the contractor's proposals are treated as a variation. So that means if the architect, for example, designs something that is incorrect, or to be fair, it's probably more often the case that, you know, a structural engineer has designed something to do with the loadings in the building that may not be 100% correct. It's very difficult to get that correct at the outset, but if there are any errors in there, then the contractor is entitled to a variation. That's clause 2.14.1. Now, errors in the contractor's proposal, for example, erroneous quantities, rates, drawing emissions, are not treated as variations. Again, you see what happens with the contractor's proposals. In the same way it happens with in the standard building contract with quantities, if the contractor makes errors in his proposals, again, typically associated with any contractor's design portions, then he is not going to be entitled to a variation. That is consistent throughout. You will not get off the hook if there are errors associated in your contractor's proposals, and the standard form is very clear on that. Now, again, you know, this is again commonly amended through the schedule of amendments. In particular, you would amend clause 2.14.1. Again, an employer is not going to want to be liable for variations as a result of any error that is within the employer's requirements. Rather, what he says, put the onus back on the contractor. You gotta understand this. You gotta get this right, because if there are any errors in there, then you have to bring them to our attention now, rather than coming back for a variation at a later point. You can understand the reasons for doing that, as employer is out and looking for cost certainty from the outset. Again, doesn't want to be liable for the errors of others, and this is a common ground for disputes, is where there is a real lack of clarity around contractors' proposals and employers' requirements. It's a topic really that deserves its own seminar in effect, and it's something that we're looking to do in the future. Okay, moving on. We're going to look at the standard billing contract with approximate quantities. Now, this is a remeasurement contract. Approximate quants are prepared by the employer and then priced by the contractor, which forms the contract sum. All work is remeasured prior to certification, and the contractor is paid based on actual quantities of work carried out. A difficulty with approximate quantities arises where quantities are not a reasonably accurate forecast of the work required, and can result in contract rates being adjusted, and a fair allowance for such difference in quantity must be made under clause 5.6.1.5. So that is you're treating that as a variation, and you'll be looking for a re-rate of approximate quantities where the original quantities do not accurately reflect the forecasted quantity. This can cause an issue with approximate quantities, and is one of the reasons why we don't see it in use very much. So to conclude that section, we've covered the remeasurement contract, the lump sum contract, and the approximate quantities contract as well, with the real emphasis being on understanding what the standard form says, and also then in future do look out for the common amendment where the employer will not want to be liable for any errors that exist in the employer's requirements. Key point to take away from this section. Okay, moving on. Okay, measurement rules. So yeah, the JCT 2016 suite of contracts has amended the measurement rules from standard method of measurement for building works 7th edition to the new rules of measurement. I've got NRM2 in there. I think we're up to NRM3. I think no, NRM2 is correct, but NRM2, NRM3 has since been adopted. Now, the measurement rules are incorporated into the contract through section 1 of the contract definitions as follows. Measurement rules. The RICS new rules of measurement, detailed measurement for building works in the form published at the base date, unless otherwise stated in the contract bills. So again, look in your contract definition section, which under JCT is section 1. They actually confirm what the measurement rules are, and you will see that has been updated. It stood as a standard method of measurement for approximately 25 years, but you know, it has been updated now to reflect the NRM. Again, look, it says the form published at the base date. So depending on the base date that you insert into the contract, which largely relates to the time when the employer's requirements were prepared and sent as tenders to the various contractors, it does get updated in line with what version is valid at the base date. So final point is that the method of measurement can be amended through the schedule of amendments. However, the use of NRM ought to be encouraged. That's pretty much, that used to happen where contractors were keen to hold on to the old SMM7. I remember in practice, I used to like SMM7, particularly because of it was the working space actually that, you know, you used to get paid for under SMM7, which has been done away with now as part of the new rules of measurement, because they want you to include that as part of the overall rate. So that's just one nuance. But look, by and large, everyone is adhering to the new rules of measurement. I don't have much experience with it myself, to be honest. It was a lot of my contracts were SMM7. But you know, if you have any comments on the new rules of measurement, please send them through. I'd be happy to understand how it's working for everyone. Okay, just an overview on what it is. So NRM1, so there was 3 points. NRM1 provides guidance on the quantification of building works for the purpose of preparing cost estimates and cost plans. It is the cornerstone of good cost management of construction contracts. So you can see that it enables more effective and accurate cost advice to be given to clients and other project team members, as well as facilitating better cost control. This information is based on historic cost database from previous projects. Now, I've put in brackets there estimating because, you know, you can see there is an emphasis on, you know, giving better cost advice and looking at cost control, including building your own database, which ideally will be an indicator for future projects and future prices that you include in future projects. So I've made a point and I've concluded at the bottom. NRM2 is written mainly for the preparation of bills of quantities and quantified schedules of works. Although the rules will be invaluable for designing and developing standard and bespoke schedules of rates, again, estimating, again, emphasis on historical database information. You can see what the new rules of measurement are trying to do here. And section 3 gives guidance on the quantification and description of maintenance works for the purpose of preparing initial order of cost estimates. The rules also aid the procurement and cost control of maintenance works, again, estimating. So you can see that there is a real strong focus on estimating and, you know, proper database logging of historical rates in order to provide clients with better cost advice at the outset. That was a key requirement for the RICS, you know, when they released the new rules of measurement. And the final point there is, you know, and this has been said about the new rules of measurement, is there's, you know, criticism being that we're in danger of knowing the price of everything, but also the value of nothing. And that is a concern at the moment with new rules of measurement. I mean, RICS are working to address that, and we'll see what they come up with in due course. So the aim of new rules of measurement is to provide more transparent pricing information, which promote a better understanding of pricing for clients and contractors to have their database, as I said earlier. In my experience, the use of bills of quantities has seriously fallen out of favor. The rise of design and build has certainly impacted this, and employers and contractors alike have embraced the design and build approach. Reason being that employers favor the flexibility of specifications and drawings rather than the straitjacket of a bill of quantities. And again, the contractors favor design and build due to the pricing strategy. And, you know, the fact that, you know, pricing, you know, tendering works as a contractor, we always say it's more of it's a dark art rather than a skill. So there you go. Look, that's a bit on measurement rules. You know, we're all adhering to them at the moment. So again, it's just pointing out that the definition in your contract has been amended, and it does confirm that the new rules of measurement are now those that ought to be adhered to. Okay, so moving on to some more legal topics, I guess. So we're looking at payment schedules. So key case here is Grove versus Balfour Beatty. So just a bit of background here. So Grove is a property developer who had employed Balfour Beatty to design and build the hotel. Now the parties had agreed a payment schedule for payments up to the contract completion date, and that was July 2015. The works were delayed and continued after the contract completion date. Balfour then issued an interim valuation for August 2015, and this is what led to the development of the law. So, when Balfour submitted their interim valuation for August 2015, well, there was no in the contract that had been agreed, there was no date allowed for in the payment schedule. So that created an issue, and Grove sought to withhold payment again on that basis. That under the contract, strictly interpreted, that Balfour Beatty no longer had any entitlement to payment. So the court said that it was deemed reasonably foreseeable that the omission of any such provision could have a commercial disadvantageous impact, and the courts would not interfere with what they deemed to be a bad bargain. Interim payments for any work under a construction contract did not mean a party was entitled to interim payments for every single piece of work under the contract. Entitlement could only be realized at the agreed intervals, which have to be specified in the contract. As such, and as a result of this, the next payment that was due to Balfour was the final account, as under the contract, this was when the next payment became due. So that's a warning to, you know, where you are incorporating payment schedules into your contract. If the works get delayed, which they often do, and your payment schedule hasn't allowed enough time in it to cover any delays, then you do run the risk of being in a kind of a vacuum where you will not have any right to further interim payment under the contract. So what will happen is, as it happened in Grove versus Balfour Beatty had to keep working without any interim payments until such time as they reached the final account. So a very painful situation for a contractor. Look, I mean, luckily enough, Balfour Beatty, you know, is a big contractor. They could suffer the short-term cash flow, but I mean, I'm not so sure, you know, the same conditions could happen for many other contractors. So look, a real word of warning. I mean, we often get asked, you know, would the scheme not fall in to accommodate or to pick up the void, and it doesn't. The courts have made that clear. And again, what they've said is that they will not interfere with what they deem to be as a bad bargain in the circumstances. So just be aware of that when you are signing up to payment schedules. There is another option in JCT, of course, where you complete interim applications section in the contract particulars. And where you do that, you say that interim applications become due on the 28th, they become due, or they be submitted rather on the 28th of the month. Now you can do it that way. If you choose to do it that way, then you don't run the risk with the payment schedule. So look, choose whichever you prefer. I like payment schedules because it's clear as to, you know, what the application date is, what the due date is, the payment notice date, the pay less notice, the final date for payment. I mean, I like that to be clear, but you know, there's a good case to be made for, you know, running with the 28th day of each month as well. At least you will not end up in a vacuum, which is a key point to consider as well. Okay, so we're going to move on. Now we're going to look at the area of pay less notices. So here so when we look at pay less notices, we have to consider what are the elements of a valid pay less notice. Now, legislation, and in particular the Housing Grants Act, has set out the two key elements that you need to have in your pay less notice. And this is common ground that, you know, that's constantly queried. So please bear these 2 points in mind. So point 1 is that you need to provide a basis of calculation. So that's basically setting out your schedule, which has your, providing a reasonable basis and just showing how you've actually calculated the pay less notice. And also that you need to show the sum considers to be due. That has to be clear. If you have those 2 points, then you have a valid pay less notice. What happens if there is an error in the pay less notice? Yeah, this is more of a point from past experience where I think I forgot in my haste to update the date of the pay less notice, and the other side said that for that reason it was invalid. Now it did put me on the back foot for a while, but when I went back and raised the question and researched it, I mean, such trivial points do not affect the validity of a pay less notice, and that is very clear in the case that we're going to now look at, which is Grove Developments versus S&T. Now again, Grove Developments pops up. This is a different case, obviously, to the Grove Developments versus Balfour Beatty. So just please bear that in mind. So we'll give a bit of background here. In 2015, Grove engaged S&T to design and build a new Premier Inn at Heathrow Terminal 4. Contract incorporated JCT design and build contract, and the works were due to complete on the 10th of October 2016. However, they were significantly delayed, which eventually reached completion on the 24th of March 17. Shortly after PC had been achieved, but before the works had been certified, the contractor sent the employer its interim application number 22, claiming payment in the net sum of over £14 million. The employer responded with its payment notice, which valued works in the net amount of 1.4 million. Shortly thereafter, the employer emailed the contractor with its pay less notice, stating its intention to deduct liquidated damages, as a result of which the employer considered sums due as at the date of the pay less notice totaling zero, therefore no payment. The contractor maintained that the employer's pay less notice was non-compliant on the basis that the employer had not attached a spreadsheet which included the basis of calculation information. Now, it was one of the spreadsheets, to bear that in mind. The employer had issued a spreadsheet under a previous pay less notice, and the calculation remained unchanged in its application number 22. So the contractor's case was that it didn't have all of the information on this pay less notice that provided a basis of calculation. Now we'll see that in the decision, the decision which was made by Justice Coulson, as he then was, in considering previous authorities on this point, Justice Coulson dismissed S&T's arguments that Grove's pay less notice had failed to specify the amount due. It was said that the question of whether a pay less notice is compliant is a matter of fact and degree. Justice Coulson also clarified that though there had been a hint in previous authorities that an employer's pay less notice might be construed more generously than a contractor's interim application, there should not be a difference in approach. Arguments from S&T were dismissed that pose hypothetical situations that might arise from a finding that a pay less notice could be compliant where a breakdown was not attached. The judge dismissed these fanciful, factful scenarios, then concluding that on the facts of this case, the reasonable recipient would have known precisely what sum was being deducted and the basis of its calculation. Now that final line there is key to is a key point to remember when you're wondering whether you have received a pay less notice. The key point being, on the facts of the case, would the reasonable recipient, would they have known precisely what sum was being deducted and the basis of its calculation? And that is really important. It's in a way it's quite reassuring that that you can't create these fanciful, factful scenarios and quite narrow interpretation to say that just because I haven't received a breakdown of one single element of the pay less notice, does that render it invalid, especially in the case where that breakdown had been previously sent either in separate email or in a separate value, separate payless notice as well. So look, quite reassuring. I hope you will agree, and do bear that point in mind. You know, when you are weighing up whether in fact you have received a valid payless notice or not. Again, remember the point, it does come down to a matter of fact and degree, okay? Right, so now we're on to the final section. So we're looking at the area of smash and grab adjudications. Now this is a term that is, you know, it's very common in industry. I mean, even my time as a QS, I used to, you know, it's constantly being spoken about. There was a lot of confusion at the time, which, you know, especially around final accounts, which thankfully Go versus S&T has addressed as well, the earlier case. So, so look, you know, what we're looking first at, what is a smash and grab claim? So in essence, a smash and grab claim is made by a contractor who acts on an employer's failure to issue a valid payless notice by claiming payment of sum stated in the interim application for payment, with no regard to the employer's assessment of the validity of such claims. So where a project has regular interim payments built in the risk is somewhat lessened by the employer's ability to undo the effects of an unjust claim in the next interim payment. For this reason, contractors have become more likely to pursue this style of claim in respect of the final interim payment, where the employer's opportunity to undo the claim by the final account may take months. So that's basically setting the scene for what happened in the case of Grove versus S&T. Now, Grove versus S&T was a significant judgment, ruling that the employer was able to challenge the amount due as a result of a smash and grab, even if there was no valid payment and/or payless notice. And again, at this point, Grove versus S&T, we're looking at it in the sense of a final account. So, you know, a lot of smash and grab adjudication, smash adjudication, you know, as we know in the Act, can happen at any time. Sometimes you see smash and grab adjudications during the course of the project, but they were also very common at final account stage. And, you know, so, and the position was that if you fail to issue a valid payless notice, or you fail to issue it in time, then the other side, you know, was entitled to payment of the full amount being claimed. So look, this, you know, Coulson again in this case, you know, in his judgment, he expressed his dissatisfaction with these types of claims, stating, "I believe that my conclusions will strengthen the system because it will reduce the number of smash and grab claims, which in my view have brought adjudication into a certain amount of disrepute." So you can see the kind of, you know, the background thinking from Coulson and the reasons why he went on to conclude as he did. Now, this was one of the issues that was decided in this case, which was the right to adjudicate what we call the true value. So the conclusions reached on this issue will be of most interest to the construction industry and represent a change of approach from the previous authorities. Coulson was clear that an employer can commence a second adjudication to seek the true value of the sum due where it has failed to serve an effective payment notice and/or payless notice to the contractor's application. And he gives 6 reasons for doing this in his decision. So the 6 reasons are, so early case authority such as Henry Boot versus Alstom Combined Cycles noted that it had always been open to the court to revise architect certificates. And this was authority for the court's ability to consider the true value of an interim payment application. And Coulson said that adjudicators have the same powers. So he was following the previous position in the courts to say adjudicators can consider this true value final account adjudication position. So the second point was that there was no limitation on the nature, scope, and extent of the dispute, which either side can refer to an adjudicator. And as such, there is no limit or restriction on the power of an adjudicator to decide this issue. So the Coulson is saying that there's no, the adjudicator is not restricted. He can consider this again, true value smash and grab adjudication position on the final account. Point 3, a second adjudication to consider the true value would be a different dispute to the validity of a pay less notice as decided in the first adjudication, as it would address questions of valuation. So the conclusion there is that there was no problem with there was no issue with jurisdiction, and adjudicators did have grounds and they did have jurisdiction to consider the true value position. Okay, point 4. So JCT distinguishes between the sum stated as due, which is the amount in the application for payment, and the sum due, which is the correct payment amount. In brackets, that is the true value. So long as the sum stated as due has been paid, the sum due can be adjudicated. So basically, what he's saying here is that if just say the employer loses on a smash and grab adjudication at the final account stage, well, that is known as the sum stated as due. And the difference here is that so long as the employer in that case has paid the sum stated as due, as in the sum that was found against him in the adjudication, he can then, you know, re-adjudicate for the sum due, which is the correct payment amount, and basically seek to correct any potential overpayments that were paid out or stated as, again, what we now know as the true value position in adjudication. Point 5, as a matter of equality and fairness, the employer's ability to adjudicate the true value of the application must be balanced with the contractor's ability to do likewise. It would be wrong to prohibit the employer from doing that which the contractor cannot do or can do. So that's basically saying that, you know, the employer can run this approach, but also that the contractor can do it. So there is grounds of equality and fairness for both parties there. The final point that Coulson made was that there is no justification for the previous authorities that distinguish the employer's ability to adjudicate where there is a final application as opposed to an interim application. There is no such distinction in the JCT form, and there is no difference between payment rights and obligations in respect of interim payments and the final payments. Okay, key point there is that if there is a smash and grab adjudication under an interim payment, then, you know, the payer can correct any potential overpayment in the next interim valuation. And what he's saying is that that position should not be any different at final account stage. So he's following the same logic and ensuring that we have the same rights when we get to final account and we are looking to determine the true value. So look, that is the position on smash and grab adjudication, and especially in relation to true value. That case, Grove versus S&T, a very interesting case. If you're looking to understand more on that, I mean, both smash and grab adjudication and also payment and or pay less notices, then do have a read. It's very interesting, and it also sets out, I guess, policy reasons in the court as to why, when the opportunity came its way, the court decided to correct any existing faults that were in the system, because previously we could not adjudicate on the true value because it was the position that that it had previously been decided, and therefore you couldn't get jurisdiction. Coulson has helpfully, clarified the position, especially on final accounts and true value. And yeah, that case is well worth a read if you wish to know more. Okay. Yeah, so a significant change in the TCC approach. He's endeavoured to bring clarity to the influx of smash and grab style adjudications and distinctions between interim and final account applications. The comments of the judge have the potential to reduce the impact of contractors' claims for payment on the basis of failure to serve a payment and/or pay a less notice, now that there is authority and support of the employer's ability to bring a second adjudication for the true value of the same application. The key point, but in order to go back for a true value adjudication, you have to pay the sum stated as due. If the employer, say after losing a smash and grab adjudication at final account, if he doesn't pay out that money, he cannot re-adjudicate. That is a very important point to note, if you find yourself in that position, okay? Look, we're going to wrap things up there. So we've covered, position on remeasurement and lump sum contracts. We've looked at measurement rules. We've also looked at payment schedules following Grow versus Balfour Beatty, pay less notices following Grow versus S&T, and the current position in relation to true value adjudications, again following that case of Grow versus S&T. So I'm going to wrap things up there. But look, if you have any questions, please direct them to Julie now, or else you can always send me an email. My email address is there. And yeah, look, thank you all for listening. And yeah, open to any questions you may now have. Okay, thank you.
Yeah, we do have a couple of questions.
Yeah.
The first one that came in was, in the event that the schedule of amendment is not altered during the contract procurement, which rules will apply if there is a contrary request?
Can you repeat that for me, Julie?
Yeah, if you look at your chat box as well, you'll be able to see
Okay,
it.
sorry, yeah.
In the event that the schedule of amendment is not altered during the contract procurement, which rules will apply if there is a contrary request?
Is not altered during the contract procurement, which rules will apply if there is a contrary request? Well, I mean, the schedule of amendments should be sent out with the contracts as part of the tender documents. So if the schedule of amendments does not get altered during the procurement process, which really the onus is on the contractor, then those are the rules that are going to apply once the contract is signed. So the contractor will have accepted the standard form of contract, but also the schedule of amendments, and which rules will apply if there's a contrary request. I mean, you're into the battle of the forms there, and basically, this can happen where parties can't agree on some clause wording. It's just a case of getting around the table and looking to close out any points, as much as possible before you actually enter into your contract. If you don't get it clarified when you sign your contract, then typically that is the area that unfortunately forms a dispute. So always just put the work in when you're signing your contracts and get clarity on your contract terms. Key to a successful project.
Okay, another question we were asked. Hasn't the use of BOQs, Bill of Quantities, declined as a direct consequence that much of a building is no longer designed fully by the client's design consultants? Even the easier elements that would have been in the past been designed have become CDP. Without a full design, you can't obviously prepare a detailed BOQ. Yeah,
absolutely right, Peter. I'm looking at your question here. 100%. I mean, this is, the BOQ, it does depend on, the progression of the design team's designs. So, as you say, traditionally and under the old model, we had to wait as QSs for, the design team to fully complete their documents in order to allow for a bill of quants. So yeah, absolutely. Clients nowadays don't want to hang around for the design team to have completed their design and then also have to wait for bills of quantities to be prepared. It's all about timing, and as soon and they want to get going now. So definitely a very valid point is that we just don't have enough certainty around the design team's designs in order to prepare Bill of Quants. Absolutely correct.
Okay, and then the final question that we've been given here is, if the IVD is included in the contract particulars as the 30th of the month, what happens in February?
Great point. The reason why it is the 28th of the month is because of February, so that you don't fall foul. Now, obviously, that's why it doesn't go on 30th or 31st, because you would end up in a vacuum. If you put in the 30th, arguably you are not entitled to a payment. You're not entitled to submit your interim valuation for the month of February, because under the contract and under the strict interpretation following Grove versus Balfour Beatty, that date simply does not happen. And so, yeah, just make sure 28th of the month always. Don't go 29th.
Okay, okay, thanks very much everybody for your questions and for turning up this evening. The recording of tonight will be live tomorrow on the website if you want to re-reference anything you've had this evening. And as Conor said several times, if you want to email in directly with any questions or queries, please feel free. In the meantime, thank you for coming and stay safe, everyone. We hope to see you all virtually very soon. Thank you.
Thanks, everyone.